Good morning. I wanted to welcome everyone to the Northwest Ohio Safety and Health Day. My name is Angie Garner, and on behalf of the entire Safety and Health Day Committee, we appreciate your attendance today. Since 1991, the Northwest Ohio Safety and Health Day has been providing free educational safety and health programs for area employers and employees. We appreciate the support of vendors and sponsors over the years that allow this program to continue and for the employers whose employees are made available to participate on the committee. We also thank those employers that have allowed the participants to join us today in order to continue with their education. We would like to recognize the Safety Council of Northwest Ohio, which is a nonprofit organization that has been serving Northwest Ohio since 1960. The mission of the Safety Council with its network of members is to enhance the quality of life by providing education, programs, and services that improve the safety, health, and environment within our community. The Safety Council provides a wide variety of safety trainings and services to support its mission. The presentation you are attending today is on independent contractors, and it's presented by Heidi Hartman. A little bit about Heidi. Heidi Hartman is an attorney within the law firm of Eastman and Smith, concentrating her practice in the areas of employment, labor law, and related litigation. She has represented large and small employers in a variety of industries, including automotive, education, manufacturing, and healthcare, in a wide assortment of employment matters and disputes. Ms. Hartman counsels employers to resolve situations within their employees and regularly defends employers in litigation if charges are filed in administrative agencies such as the U.S. Department of Labor's Wage and Hour Division, Equal Employment Opportunity Commission, Ohio Civil Rights Commission, and National Labor Relations Board. We ask at this time if everyone would put their computers on mute if not already done, and please turn off your video. If you have questions, you can simply type them into the chat and they will be answered at the end of the presentation in the last 10 minutes. Please keep all chat to the topic and presentation and respect the speaker. And now I would like to welcome Heidi Hartman.
Thank you, Angie, for that kind introduction. I appreciate it. Can you hear me okay?
Yes.
Great. And can you see my slides?
Yes.
Perfect. Well, good morning, everyone. As Angie said, I'm Heidi Hartman. I'm a partner with the law firm Eastman and Smith in the Labor and Employment section. It's my honor to be here with you today, joining you for the Northwest Ohio Health and Safety Day. It is a rather gray and rainy morning here in my neck of Northwest Ohio in Perrysburg, so a perfect opportunity to start our day with talking about independent contractors and how to work that practice both with subcontractors and independent contractors. And I'll use those two terms interchangeably during the presentation. So in many cases, a subcontractor relationship is obvious and traditionally well established. For example, take the construction industry. In that industry, you would have a general contractor with contracts with specialty subcontractors to perform certain aspects of a project. Lots of what we will discuss today is applicable to those formal, traditional subcontractor relationships. But we're going to spend a lot of time talking about the more tricky contractor relationships. For example, the ones where you have a job and you're filling it with an applicant who asks to be treated as an independent contractor. Or, for example, where you have a job that requires hiring, but it's not quite clear whether that position is going to be a long-term position or necessary for generating your products and services. We're going to discuss the benefits of classifying workers as independent contractors and the risks associated with doing so. We'll also cover the various tests that are applied to determine whether a worker should be considered an independent contractor or an employee. While nothing in this presentation is or should be construed to be legal advice, we're generally going to talk about how to document and manage an independent contractor relationship to limit the risk that you will not be able to prove that the individual is a true independent contractor. Those tips will be useful also for your more traditional subcontractor relationships, but it will help you to define the parameters of who is an employee and who is a subcontractor. And in turn, those parameters can be applied to determine whether, for example, you have liability under Ohio workers' compensation programs for individuals who are injured in your workplace, and a variety of other potential risks. So in terms of the benefits of independent contractors, I'm going to begin from the contractor's perspective, using my example of someone who asks to be treated as an independent contractor rather than an employee. For that person, they may be thinking that they get some kind of tax benefit. That is, that you won't be withholding the FICA taxes or paying them on their behalf. Some independent contractors believe that it is a more informal, under the table type of relationship. It's not the case, of course, and they do have tax liabilities and in fact end up paying more taxes because they have to contribute for themselves as well as the employer tax. But in a lot of cases, individuals think sometimes that they have a benefit financially. Truly, the primary benefit of being an independent contractor is being in business for yourself. Independent contractors are entrepreneurs who depend on themselves for work, who have the flexibility of setting their own schedule, selecting what projects or jobs they want to work, and having a variety in the type of work that they prefer. They choose to do what to do and when to do it, if at all. Independent contractors generally have greater autonomy and more flexibility in their hours, which provides them with more control over management of their time. From a business perspective, having workers who are classified as independent contractors allows for a flexible and dynamic workforce of workers who are generally quite satisfied because they have the autonomy that we just talked about. It allows businesses to avoid paying the minimum wage or overtime or keeping records required by the Fair Labor Standards Act. It alleviates exposure to statutory liability, that laws that prohibit employment discrimination or set safety rules or other costly requirements. When you have an individual who is not an employee, they're not subject to OSHA rules, for example, or you're not subject to liability for violations, rather, or you don't have to pay for expensive health care. Independent contractors are not required to be covered under employee benefits, and companies therefore avoid costs related to health insurance, retirement plans, and paid time off by engaging independent contractors rather than employees. They can also avoid tax obligations and contributions to workers' compensation or unemployment compensation insurance. And for those companies that don't look favorably on having a unionized workforce, those workers who are independent contractors cannot organize or join a union. As we'll discuss, though, in a few minutes, all of the potential benefits of classifying individuals as independent contractors also comes with the risk that a state agency or a court will determine that there's been a misclassification and that the individual who has been classified as a independent contractor is truly an employee. So how might you find your company on the receiving end of a misclassification determination? It can come from a variety of different directions because there are so many competing interests in making sure that individuals who are truly employees are treated properly. For example, individual lawsuits, private plaintiffs on this slide. You may have a worker who is classified as an independent contractor who puts in 80 hours of work every week and isn't subject to overtime because they're not an employee or treated as an employee under the Fair Labor Standards Act. And let's say that person who didn't receive the overtime sues you, arguing that they should have been classified as an employee and therefore entitled to overtime. The risk that creates under the Fair Labor Standards Act is huge. The Fair Labor Standards Act creates a private right of action for putative employees, and plaintiffs' lawyers absolutely love this type of case. And there are some good financial reasons that plaintiffs' lawyers love this kind of case. First, because the Fair Labor Standards Act gives prevailing plaintiffs, so they have to prove that they were employees, or you have to prove that they were an independent contractor. But if they prevail, they're automatically entitled to double damages or potentially triple damages if there is a willful violation of the Fair Labor Standards Act found. The Fair Labor Standards Act also requires defendant employers to pay for the reasonable attorney's fees for the plaintiff's lawyers if they prevail in a lawsuit. And I can guarantee that reasonable attorney's fees on the plaintiff side look nothing like the reasonable attorney's fees that you'll see on the defense side. You'll have people billing 12 hours a day, 5 to 7 days a week, and wish that you were a money printing company rather than whatever it is that you do, because it exponentially increases the risk of liability. Add to that, as if that wasn't enough, the fact that in cases that are brought under the Fair Labor Standards Act, the plaintiffs can file a collective action. And what that means is that their lawyers can ask the judge to order employers to provide a list of the names and addresses of every other worker who was treated the same way as their plaintiff. So if they're hourly workers, all the hourly workers in your company can be placed on this list and contacted by the plaintiff's attorneys, asking whether they want to join the case. And if they do, they have to say so, but they get added, and then their damages get compounded with the other plaintiff's damages, and the attorney's fees compile on top of all of that. And as the collective group grows, probably the team of lawyers grows. So you can see that that gets to be a really, really expensive type of claim. So it's very important from the Fair Labor Standards Act perspective to make sure that you're appropriately treating individuals as either employees or independent contractors. Aside from individuals, there are other authorities that have a deep interest in companies' practices with respect to compensation and, more specifically, taxable wages. That includes, obviously, the IRS, state unemployment and workers' compensation agencies, and tax authorities. All of those agencies have the power to either investigate complaints or conduct audits related to the classification of workers. So if you are reporting to the IRS that you engage a large number of independent contractors in a given year, that can raise the specter with them that there's something that they might want to look at, and they can conduct an audit. Every law that governs employment, unfortunately, uses a slightly different test to evaluate the employment versus independent contractor relationship. Of course, because lawyers can't make anything less complicated than the most complicated thing. As a result, a worker can ultimately be determined by ODJFS, for example, to be an employee, but the IRS might come to a different conclusion and find that same worker to be an independent contractor. So the risks have to be balanced, and should always be balanced, especially in years where we have Democrats in the White House. You know, the approaches do change in the agencies with different perspectives in the president's chair. So generally, the safe thing to do is to err in terms of finding someone to be an employee. But keep in mind as well that it's probably not going to only be ODJFS and the IRS who are interested in that relationship if one or the other one does become interested. The IRS and the Department of Labor have a memorandum of understanding that creates a partnership between those two very separate and with very different goals, agencies, and that provides for data sharing, for referrals for audits, coordinated enforcement of their respective laws, joint outreach, and compliance assistance. So I guess it goes without saying that if the IRS identifies a misclassification, the Department of Labor is probably also going to come knocking along with those plaintiffs' lawyers, and they might, in fact, share information with your state agencies as well. Although in Ohio right now, the Department of Labor does not have a memorandum of understanding with respect to information sharing. That can change at any given time. There are a number of potential ways that claims for misclassification can be approached, all of them that carry potential consequences. We already discussed the failure to pay minimum wage or overtime, but claims could also be made against your company for unpaid benefits, for the failure to contribute to premiums for workers' compensation or unemployment for those individuals that you classify as independent contractors, or failure to contribute to Social Security and Medicare. And the consequences can be costly. It doesn't include only back pay, but you get unpaid employee benefits added to that. You get unpaid workers' compensation obligations added to that, unpaid insurance obligations. And then, of course, as I said, there's liquidated damages. Under the Fair Labor Standards Act, there are penalties that are applied by the IRS. There's interest and potentially attorney's fees, which is all pretty expensive. So how can we avoid claims and potential consequences for misclassification? It's easy, and the answer is you just don't misclassify. But not misclassifying is unfortunately a quite complicated proposition because, as I mentioned, each of the interested agencies has a different test that they apply when they're determining whether someone is considered an independent contractor or an employee. So avoiding misclassification requires consideration and application of more than a half dozen applicable tests to the relationship. Because of the way the definition of independent contractors has developed through court decisions all over the nation over the last 70 years, there are different tests based on circumstances and the legal context in which the analysis arises. Today, we're going to focus on a few of those tests so that you can recognize the extent to which they overlap or complement one another, and really get a sense for the themes that are going to be applied when determining whether an individual can properly be classified as an independent contractor. Specifically, we're going to talk about the test under the common law that courts apply when a statute does not provide any definition of employee or employment. We're going to review the test that the Department of Labor is currently supposed to be applying under the Fair Labor Standards Act, and we'll talk about why I say currently supposed to be applying when we get to that slide. We'll briefly cover the IRS test and also the test applied by the NLRB. First, the common law test, which is used in situations, as I said, where the statute that governs the relationship does not define an employee versus an independent contractor. What's an example of that? Well, for those of you who are federal contractors who have to be in compliance with OFCCP regulations and affirmative action programs, the common law test is applied in that situation to determine whether an individual has to be counted in your affirmative action plan and reporting to OFCCP. The common law test is a very fact-specific and case-by-case assessment. And that means that the nature of the relationship with every single individual who may be considered a contractor and not an employee has to be scrutinized through what is known by mainly lawyers is the Darden test. That is a set of factors that the Supreme Court announced in a 1992 decision with an individual named whose last name was Darden, hence the Darden factors. While no one factor under that test is decisive, the factors that control or indicate the extent to which the contractor controls the manner and means of that person's individual performance will typically be found to be the most important in this analysis. So talking about the Darden factors, the first one is the contractor's right to control when, where, and how that individual performs the job. If the contractor retains substantial control over when, where, and how they perform the work, that's a strong indicator that the individual is a contractor, an independent contractor. If the federal contractor retains that control, so the company which is a federal contractor under the OFCCP, retains that control, that then is a strong indicator that the individual is an employee. The other factor, another factor, is the skill required for the job. Independent contractors typically have their own methods for doing what they're hired to do, have specialized knowledge of the work to be performed, and don't need training from the federal contractor, company, or employer. They're hired because of their specialized knowledge, not because they need to be taught something by the contractor's business. So that's a second factor that's considered. Third factor, the source of instrumentalities or tools. Generally, independent contractors procure and use their own equipment and the materials that they need to perform their work. If a contractor is supplying the tools necessary or the equipment necessary to perform the job, that tends to show the existence of an employment relationship. The location of the work is also another factor. If the individual is working at a location that is owned or controlled by the contractor, that could, in some cases, be considered to be an employment relationship. But if the individual retains the discretion to perform work at any other location, that might indicate non-employee status. Of course, that factor would not be particularly important when we're talking about, say, a construction contractor relationship with a subcontractor or independent contractor. And that's because the work has to be performed in one place. So again, it varies from circumstance to circumstance, case by case. Another factor that's considered under the Darden test is the duration of the relationship between the parties. So an extended continuing relationship without a predefined duration could indicate the existence of an employment relationship. Independent contractors are more likely to be performing discrete tasks over a predetermined amount of time that's agreed upon in advance by the parties. Another factor under the Darden test is whether the contractor has the ability to assign additional projects to the individual. When I say contractor there, I mean the company or the federal contractor. Independent contractors typically agree to provide specific services to a company, and they have the freedom to accept or decline additional work or additional jobs or expand the scope of what they agreed to do. If that person has the discretion to do that, that would indicate an independent contractor relationship. If that discretion is not maintained by the individual, that would err in favor of the existence of an employment relationship. Another factor is the extent that the individual has discretion over when and how long to work. So if a company is setting the individual's hours or giving general constraints about the time within which the work has to be performed on a day-to-day basis, that is more indicative of an employment relationship than an independent contractor relationship. Method of payment is also a factor under this test. So independent contractors are generally paid an amount that's agreed upon in advance for performing a particular job. If an individual is paid a salary or is paid by the hour or is paid by the week or the month, that might err in favor of a finding by the court that the individual would be an employee. Contractors generally retain the right to hire and pay assistants. So if an employer is requiring that the individual themselves perform the work without being able to delegate, or restricts the individual's ability to hire others to perform the work, that would err in favor of finding an employment relationship. Another factor, lots of factors here, is whether the individual's work is part of the regular business of the contractor. So employees regularly perform jobs that are a routine part of an employer's business, whereas independent contractors generally perform specialized work that lies outside of the employer's normal business. Another factor is whether the contractor itself, purported independent contractor, is a business. If you're hiring a company to perform work, even if that company is one individual, that would generally be more acceptable as an independent contractor relationship than paying an individual. So independent contractors are usually engaged in their own separate business when they perform work for a contractor. Employee benefits is another factor that will be taken into consideration. So employees typically receive benefits like insurance, leave, workers' comp. Independent contractors normally do not. So that is an overview, general overview of the Dardenne factors to determine whether someone is an independent contractor. We have the IRS, which applies a common law control test, which is different from the Dardenne factors. We have an EEOC standard that's applied under Title VII, the ADA or the ADEA, and that test is a 16-factor test. And different states apply different tests for wage and hour and unemployment and workers' compensation compliance purposes. So we're going to move on to the Fair Labor Standards Act and talk about the basics there and how they distinguish an employee from an independent contractor. The Fair Labor Standards Act was signed into law in 1938 and requires, among other things, that employers pay at least the federal minimum wage for every hour worked and overtime worked for every hour over 40 in a work week, and also mandates that employers keep certain records about their employees. The Fair Labor Standards Act defines employer as a person acting directly or indirectly in the interest of an employer in relation to an employee. And it defines employee to mean any individual employed by an employer. Super helpful, right? When we talk about being employed, the Fair Labor Standards Act defines employ as to suffer or permit to work. The federal courts and the Supreme Court have held that the definition of employ was not intended to stamp all persons as employees, and they recognize that independent contractors are not employees for purposes of the Fair Labor Standards Act. But since the statute did not define independent contractor, decisions of the court over the decades have set forth certain factors to be considered when differentiating independent contractors from employees. But the Department of Labor itself has never issued a rule until basically the advent of the gig economy. In January of 2021, in the waning days of the Trump administration, the U.S. Department of Labor issued a final rule that for the first time since the Fair Labor Standards Act was enacted in 1938, set a standard for how to differentiate between an employee and an independent contractor under the Fair Labor Standards Act. As I mentioned, that was in the waning days of the Trump administration. So the final rule was scheduled to take effect March 8th, 2021, after the Biden administration was sworn in and in control. And as you may recall, shortly after the Biden administration took office, the Department of Labor delayed the effective date of this rule and other late Trump era rules. This wasn't necessarily a surprise, given that the previous administration, under which President Biden served as vice president, the Obama administration, had a very strong theme that almost every worker is an employee. So the Obama administration, as the gig economy was developing, took the position that these Uber drivers and these Lyft drivers and DoorDash drivers and other gig economy type of workers should be treated as employees, whereas these companies treated them as independent contractors. After the Biden administration put a delay on the effective date of the rule, they ultimately issued a new final rule that withdrew the Trump era standard. Various business groups whose business models depend largely on their ability to classify their workforce as independent contractors rather than employees filed a lawsuit in a federal court in Texas. And that included like industry groups representing builders, contractors, and financial services firms. Their lawsuit challenged the delay and the withdrawal of the final rule. And on March 14th of this year, the federal court in Texas vacated the delay and the withdrawal and held that the independent contractor rule became effective March 8th, 2021, the rule's original effective date. So according to this court, the final rule that was issued in 2021 and scheduled to go into effect in March of 2021 actually was effective in March of 2021. The Department of Labor has filed an appeal to the Fifth Circuit challenging that, but pending the appeal, the standard the Department of Labor should be applying, according to the court, to determine worker status is an economic dependence test, which considers the following factors. First, the nature and degree of control over the work. What does that mean? Well, the rule explains that where the individual exercises key control or control over key aspects of performance, like setting their own schedule, or by virtue of the ability to work for others, other companies, maybe including the hiring party's competitors, that would favor an independent contractor relationship. If, however, the hiring party controls the schedule of the individual or the individual's workload, or indirectly or directly requires that individual to work exclusively for the hiring party, that would favor an employment relationship. The rule makes clear that requiring an individual to comply with like specific legal requirements or to satisfy certain health and safety standards or meet contractually agreed upon deadlines or quality standards, those are not aspects of that would demonstrate a degree of control over the performance, but instead, under the rule or as it explains, those are typical of contractual relationships between businesses and don't necessarily constitute control over the individual that would make that person more or less likely to be considered an employee. The second factor that is primarily considered under this rule is the opportunity for profit or loss. if the individual can exercise initiative or manage his investment in or spending on helpers or equipment to further his work or earn profits or incur losses, that would weigh in favor of an independent contractor finding. If someone's unable to affect earnings with the hiring party, or can only do so by working more hours or working faster, that person would be considered an employee under the rule. The amount of skill required for the work, again, hearkening back to the Darden factors, if the work requires a specialized skill that the hiring party company does not provide, that would weigh in favor of an independent contractor relationship. But if no special skill or training is required, that would maybe weigh in favor of an employment relationship. The degree of permanence, again, similar to one of the Darden factors. If by design, the role of the hired individual is definite in duration or sporadic, that would be considered more likely to be an independent contractor relationship. The rule states that this may include regularly occurring fixed periods of work, but the permanence of a relationship weighs in favor of employment if it's indefinite in duration or continuous. The fifth factor listed in the rule is whether the work is an integrated unit of production. Again, hearkening back to what we've heard in the Darden factors, a person would be considered to be an employee if the work they're performing is a component of the production process for a good or service that is provided by the hiring party. They would be considered an independent contractor if the work is segregated from the potential employer's production process. So these are the only factors that the rule takes into account to determine whether a worker is economically dependent upon the alleged employer. Some courts use additional factors. Each court would place varying weight on each factors, but ultimately it's about economic dependence. And that's the focus of all of these considerations. The rule that the Department of Labor issued also emphasizes the primacy of actual practice. And what does that mean to us? Well, first of all, having a written agreement with a worker who's classified as an independent contractor is very important, but it does not guarantee that worker's status will be found to be an independent contractor relationship. Your best laid plans to establish an independent contractor relationship through a written agreement, frankly, won't be worth the paper it's printed on if the relationship in practice is not consistent with what is written in the agreement. Under the Trump era final rule, the DOL made clear that the actual practice of those involved in the relationship is more important than what the contract language says. For example, if the contract language says that the hired party is free to work for any competing companies, but as a practical matter, because of the way the work is required to be performed, prevents that person from working elsewhere, the practice might trump the written document. Likewise, a business's contractual authority to supervise or discipline an individual may be of little relevance if in practice the business never exercises such authority. So if a company retains the right to discipline someone, which would err in favor of an employment relationship, waiving that right and not doing so in practice might allow that company to argue in favor of the independent contractor status. The IRS employs a 20-factor test that is derived from application of the common law standard that's here for your review and use in the future. And the NLRB has a separate rule, and we don't really need to go through the factors because they, as I said, overlap and are similar. But this is just an example of how things change from administration to administration. You have one administration that announces as a matter of policy a rule, and then when another party in the future has power and has control over a particular agency, they can reverse the prior holdings and reinstate what was formerly considered the standard. So standards are shifting politically, especially at the federal level. I've also included in this slide here the fact that states have more expansive laws that test the employment versus independent contractor relationship. And then there is an ABC test, and this is a test that is applied in the state of California, the state of Massachusetts, Connecticut, and others for determining whether someone is an independent contractor. This was a proposal, and progressives really embrace this definition of employer versus independent contractor. So, it may be something that we see in the future, so I thought I would include it for you. In order to meet this test, an individual has to meet all three of these factors. So it's not just weighing a number of factors and just finding which one tips the scales. In this test, all three have to be met. So the worker has to be free from control and direction of the hirer in connection with the performance of the work, both under the contract and in the performance of the work. In fact, the worker has to perform work that is outside the employer's usual course of business. And the worker has to be customarily engaged in an independently established trade, occupation, or business of the same nature involved in the performance of the work. So basically what that's requiring is that the person have their own business and run it as a business that they are primarily focused on.
Heidi, you have about 10 minutes left in the session. There are not any questions in the chat, so unless anything else pops up, you can go ahead and finish with your presentation, but there is only about 10 minutes left.
Perfect. Thank you, Angie.
Sure
and happy to answer questions if you have any, and Angie will certainly let me know, and otherwise I'm just going to plow through here. So as we discussed a few minutes ago, the written agreement and its terms are not necessarily determinative of a relationship, but it's always beneficial to clearly establish that the parties' understanding is that they are entering an independent contractor relationship. So taking what we've learned about the various factors that are applied when determining the relationship, we're going to talk about some best practices for documentation of an independent contractor relationship. First of all, the agreement should provide that the services the worker will provide are defined. And you should avoid language stating that the hiring party is going to control or in some way supervise the worker's performance of the work. The agreement should specifically exclude the worker from eligibility to participate in company benefits of any kind. The document should specify that the individual is not restricted from performing services for others. There is no non-compete obligation that is consistent with an independent contractor relationship. The document should also make clear that the individual is responsible for the time, place, means by which the work is performed, and that the worker is going to use their own equipment at their own expense with their own supplies and other materials necessary. If it's possible to predict at the time that you're entering the agreement, it should set a specific deadline for the work to be completed, so that you can demonstrate that the work is definite in duration and not continuous or indefinite. Other best practices include making clear that the company is going to issue a 1099 to the worker for performance of the project. Also specifically authorizing that worker to hire and fire others to perform the work and to set the schedule and hours of the work. Making the worker responsible for supervising his own employees. And it is, of course, advisable best practice that the worker provide his or her own general liability, unemployment, and workers' compensation insurance, and pay all taxes and for any necessary licenses for the work. So now that you have best practices for documentation of the relationship, remember the importance of the actual practice and make sure that in practice, you're treating the person as an independent contractor. Company personnel should focus on the end product rather than the process of the work. It's important for your company personnel who are involved in the project to understand that this is a contractual and not an employment relationship. For example, the failure of the contractor or its employees to perform should be addressed not as a disciplinary issue, but rather as a breach of contract issue. The company should not include the worker in employee meetings or provide training to the worker. And if possible, I would encourage that the company pay a separate business rather than an individual to really make sure that the relationship is being treated appropriately. Some further tips when interacting with independent contractors: to the extent that you ever have a contractor who files an unemployment claim or a workers' compensation claim, those should be opposed so that you can set a precedent and make clear to the agencies that you have an appropriate relationship and that you're willing to defend it. It's another best practice to avoid rebranding employees as independent contractors. Reason for that is it raises red flags if you have someone to whom you've issued W-2s for a length of time and then switch to a 1099 type of relationship. It's unlikely, unless that person changes careers and starts a new business, that you can have them doing the same type of work and then be an independent contractor rather than employee. Avoiding hiring outsiders to perform work side by side with employees doing the actual work of the business. It's different to hire a temp to come in and do work side by side, the production work, for example, but it's not going to be indicative of an independent contractor relationship if you hire someone to come in and do the work that all of your other employees do. If you can, avoid sole proprietors in favor of businesses with employees. That enhances the chances of proving that you have an independent contractor relationship. Reviewing benefit plans to assure exclusion of contractors, and obtaining evidence that the contractor is actually a business. So what that means is having them provide you with their certificates of coverage for unemployment, for workers' compensation insurance, general liability insurance, all the necessary licenses. All right. Well, I have 5 minutes to spare, so I'm going to ask if anyone has any questions.
I do not see anything in chat.
Well, I hope that that was a useful exercise. It's always a good idea to, from time to time, revisit what our relationships are with individuals in the workplace and to make sure that we have a good legal basis for treating individuals the way that we are, in order to provide, background and a good defense if we ever are faced with needing to defend. So Charlotte, I think this has been recorded, so you should be able to view it, correct, Angie?
That's correct, yes. So if you do need to view it at a later date, I'll make note of that and I'll just send that out in email as long as you're registered.
Okay, well, I appreciate your time and attention. I don't think you have to hear from any other lawyers today, so I think it's a good start to your day, and I wish you a successful presentation day. Hope you all enjoy it.
Thanks so much, Heidi.
You're very welcome. Thank you.